Hi, good afternoon, everybody. Welcome to the National Immigration Law Center's webinar. As you know, we've been busy providing information since the elections, and we have yet more information to provide you today about recent developments around immigration policy and immigration law. So one housekeeping note before we start is we are now switching to webcast. So in the past, people could call in through their phones. Now you can only listen in through your computers. And the reason we did that is because we had a 1,000-person limit on our previous software, and with webcast, we can make sure that we accommodate everybody who wants to join the call. So I'm going to briefly just run through the agenda. We're very pleased to have not only NILC staff, but also other guest speakers with us today to talk about the Muslim and refugee ban version 2.0, as well as recent updates around DACA and immigration enforcement practices. And we have a spectrum of speakers because we want to highlight the fact that there are multiple strategies, and we need to engage in these multiple strategies to really challenge what we're seeing from the administration. We also have our NILC staff person, Matt, who's going to focus on talking about the proposed executive order on public charge issues. So at the end, we'll have time for questions, and as usual, please type your questions into the chat box, and we'll try to ask as many of them as we can. So without further ado, I'm going to turn it over first to my colleague, Abide, who's going to talk about an overview of the new Muslim and refugee ban.
Hi, everyone. Thanks for joining us today. As most of you know, this past Monday on March 6th, the President signed a 2.0 version of the Muslim and refugee ban. This is obviously coming weeks after a February 9th Ninth Circuit decision that enjoined many parts of the original ban, and despite the administration's initial threat that they would see us in court and fight this tooth and nail in the courts, what they did is obviously took heed of what was in the decision from the Ninth Circuit and attempted to revise it in ways that they thought might insulate them from further challenge. So while we don't agree with that, and you'll hear a little bit more about why, I'm going to run through what is different about this version in writing and versus what's still the same. So some key things are, number one, there is a phase-in period, meaning that even though it was signed on March 6th, it doesn't actually go into effect until March 16th. That's partly in response to, as we saw on January 27th, that even before that order was actually signed, there was chaos and confusion in airports across the world. So there's this phase-in period now to hopefully mitigate some of that. In the prior version of the ban, there were 7 Muslim-majority countries listed. This time, Iraq is removed from that list of banned countries. I think this is partly due to some pressure, given the fact that there are many Iraqi nationals who have assisted the U.S. Army overseas, and some of the high-profile cases that Department of Defense was very vocally concerned about. So there's elimination of Iraq, but there are still the 6 other countries, and there's also the possibility of adding more countries. For people who are nationals of the banned countries, there are explicit exemptions that are written in. So before, we saw with the first order that there were sort of periodic updates from CBP and DHS clarifying who was covered by the ban and versus who was exempt. This time there is explicit reference to people who are lawful permanent residents or green card holders, people who are dual nationals who have a passport from a non-banned country, people who are valid visa holders on January 27th, which was the day of the original ban, or have a valid visa on March 16th. I should also specify that as of March 16th, this new 2.0 version of the refugee and Muslim ban will revoke and replace that original executive order. There's also an explicit mention of waivers that are case-by-case, individualized waiver that can be provided if someone can demonstrate undue hardship, if they're not allowed entry into the U.S., if they can also show that there's no national security threat posed by their entry into the U.S., and if it's in the national interest. While there are some examples of what that means that were included in the executive order, it's clearly really vague. I think something that was abundantly apparent to all of us with the rollout of the original ban was that there was never uniform interpretation or application. It felt like people were applying it indiscriminately in some cases and with great harm. So I think that even though there are these exemptions and the waivers, we'll obviously be monitoring very closely what that actually means in practice. And it may well, with respect to the waivers at least, may simply be lip service to some of the strong language in the Ninth Circuit decision. Another thing that's different about this version is that it doesn't explicitly penalize Syrian refugees by subjecting them to an indefinite ban. And it also removes any preferential treatment for people who are members of religious minorities. So those are important distinctions. They're notable, but at the same time, if we move to the next slide, I want to focus on what's the same, because fundamentally, what's at the central premise of the ban is that it's intended to leave out refugees and individuals from Muslim-majority countries. So there is still a 90-day ban on issuing visas or allowing entry into the U.S. for people who are from 6 Muslim-majority countries. So again, it went from 7 to 6 because Iraq is no longer on the list. And it still allows for the possibility of designating other countries. And in fact, there's already been mention by DHS that there could be many other countries included going forward. So I think that really leaves open the possibility of a 90-day ban turning into a much longer one and also sweeping in other countries. It also completely suspends the entire refugee admissions program for 120 days as of the effective date, so as of March 16th. So while it doesn't single out Syrians, it still shuts out the most vulnerable people who are seeking protection, and many of whom have gone through years of vetting and security clearance, family separation, and really endured horrific circumstances, and now they're being told, they will be told that they can't come for this period. And as we know, given the way that the refugee admissions program works, if you lose your temporary period of security clearance, you sort of fall out of line, and so a 120-day suspension in practical terms could actually create a much longer backlog of up to a couple of years. It still slashes the overall number of refugees that we're admitting into the United States from 110 to 50,000. To date, there's been around 35,000 or so refugees who've been admitted for this fiscal year. So that means that for the rest of the fiscal year, there's only 15,000 additional refugees who'd be allowed entry. I think collectively that means a real shutdown in many ways of the refugee admissions program. It still suspends the visa interview waiver program, which means in practical terms that many, many people who previously could simply because of their age or if they're repeat visa applicants, they would be able to mail in or drop off their visa applications for renewals. Now they're going to have to go through an interview process, which means there's going to be a backlog for all people, not just people from these 6 countries who are seeking entry into the U.S. It's going to create major delays, and even though the executive order says that they will supply some additional staff, I think this is something that is in many ways not something the U.S. consulates are prepared for. And then at the core of all of this is that you can change the date, you can make some cosmetic tweaks, but at the end of the day, the same discriminatory intent that motivated the first ban is what's driving this one. So that's why we're calling it a 2.0 version. It doesn't change the fact that just because something is slightly less flagrantly unconstitutional, it's still unconstitutional, and that's not a technicality. And I will leave it to later in this conversation for my colleague to talk a little bit more about what some of those legal challenges are.
All right, thank you, Abide. And we also wanted to make sure we covered the responses to the Refugee and Muslim Ban 2.0. So to lead us in that discussion is Alika, who's part of Asian Americans Advancing Justice, Asian Law Caucus in the Bay Area.
Thanks, everyone, and thanks for having me. In addition, yes, once the ban was dropped and even before the 2.0 version, still the communities, Arab, Middle Eastern, Muslim, South Asian, right, just still very much impacted, right, and very worried and anxious and scared and kind of wondering if their cases are going to be in limbo. What's the community response going to be, right? We have a lot of community members who have been waiting for years for visas to come through and are almost at the tail end of that process. So what does it mean in that respect? So that heaviness is still very much felt in the communities. In terms of the community and advocacy responses, one piece to flag is that there were, in fact, quite a few contingency plans in place at the different airports across the country, right? And those were ready and available to be used even when we didn't know that there would be the 10-day implementation phase. And then, of course, with the 10 days, that gives us additional time to be ready at the airports if needed, and reach out to other areas and geographies and institutions where there may be impacts immediately and these cases felt. So the implementation period definitely helped, right? And in terms of the San Francisco airport, which is what I can speak to, our strong partners at CARE, San Francisco Bay Area, One Justice, the Stanford Clinic, Tahrir Center, all really monitoring and having shifts ready. And that part is really important for peace of mind for the community and to be ready. The second core strategy that we're seeing in terms of a response, right, is community advisories and know your rights materials and know your rights presentations that are going out in multiple languages, obviously English and Farsi and Arabic being the primary languages. And we've seen some great community advisories come out from, CARE, the Advancing Justices, ADC, and several other organizations as well. So the community really needs information about what's happening and why, and the fact that this is a 2.0, but they also need the nuances, right, about whether this does impact them as green card holders or not, or for the applications and petitions that folks have been waiting on in terms of family unification. The next core strategy that we're seeing in terms of response to the 2.0 is from a communications perspective. So really making sure that our allies and the public understands, just as Abide pointed out, that this is in fact, there are minor facial changes and that this is a 2.0 version, that the discriminatory underlying piece of this, right, is still very much intact. And also seeing a great effort from MEMSA communities themselves, from those community leaders to be out there in media and centering the narrative on the community itself. Empower sent out a great email and summary about the different op-eds of Muslim community leaders. So really encourage folks to sign up for the Empower alerts and to read the different op-eds written by Muslim community leaders. So we're seeing really, again, the communications piece being centered and grounded in MEMSA community leaders themselves, from folks who are very much directly impacted. The next strategy that is critical and very much moving forward is the organizing piece, right? So a lot of folks might have heard that there's going to be a large action tomorrow, and a big shout out to the Yemeni community through Yemeni United against the Muslim ban. Those actions and marches are going to be rolled out in California, New York, Michigan, Virginia, and more. You can follow it through the Yemenis Against Ban hashtag, and really a strong showing that we are not okay with this ban. This is deeply impactful. This is a 2.0 version, and we will continue to mobilize. There are also going to be actions on March 16th across the country, and just to emphasize how important not just the legal strategy, but the community level, the actions, the mobilization, and how important that was to the legal strategies on the ground at the different airports. At SFO, certainly having allies and communities there in the hundreds made all the difference in terms of the legal ability to work and get folks released from detention at the airports. So really supporting and getting involved in those organizing efforts as well. And in addition, what we're seeing is, from a bigger picture perspective, that the fact that this is a Muslim ban, right, the fact that this does impact many of the AMEMSA immigrant communities, and simultaneously we're seeing the executive orders for the interior and enforcement being rolled out. At least in California, we're seeing an increase in AMEMSA communities being involved in broader immigrant rights efforts and broader immigrant rights groups, and having that conversation escalate because we are both communities are being targeted at such a detrimental rate. So seeing different policies moving forward that are not specific to the travel ban, but are very much related to discrimination and targeting of AMEMSA communities and other immigrant communities in California moving forward. So happy to answer questions about that at any time.
Thank you. And actually, as a reminder to everybody, please do type your questions into the chat box. We're actually going to take a couple of questions after the next presentation, so please do send in your questions. And our next presenter is Justin, who is a staff attorney with NILC, who's going to talk about some of the ongoing litigation challenging the Muslim ban.
Thanks, Xiuming, and thanks everyone for joining. As I'm sure you all are aware, there are lots of cases were filed in the hours and days after the first executive order was issued, challenging it in a variety of contexts. And so now, we've had a few days, we're starting to see how these cases are going to evolve to respond to the next executive order. So the most recent information that we have is that the state of Hawaii will be seeking a temporary restraining order and a preliminary injunction. They'll be seeking to block the new executive order in the case that they filed in the district court in Hawaii. They're going to try to get an order from the judge blocking the new executive order before it goes into effect, which, as was mentioned, would be on March 16th, next Wednesday, or is that Thursday? At any rate, and then we've also heard that in